Good morning. This is a course that I'm going to discuss about. It's the Business Law 526 offered by CALMAT for 2011. This is a final project written by, my name is Darren Tay, assigned by Professor Samuel Tong. I'd like to talk about is the case that Glenayre Electronics announced to its employee that it could inspect the laptops it furnished for its employees to use. An employee challenged the inspection of his laptop as a violation of his privacy. So could the company search the laptops? Okay, this is Muick versus Glenayre Electronics 280 F3D 741 at the 7th Circuit Court. Okay, so the fact is, Muick, an employee, was arrested on charge of receiving and possessing child pornography in violations of the federal law. Okay, so Glenayre seized from Muick work area the laptop computer that it have furnished him for use at work and held it until a warrant to search it could be obtained. Okay, so of course that he was later convicted and imprisoned. Okay, so basically now he has sued his former employer, claiming that Glenayre, acting under the color of federal law, see the properties and privilege and personal, financial, and contact data. Okay, so of course Muick also charged that Glenayre violated rights conferred on him by Illinois law. Okay, the district court had diversity as well as supplemental jurisdiction over these claims. Okay, so next slide I'd like to talk about is I picked three authorities. Basically is the district judge rightly granted summary of the judgment to this Glenayre on this Muick federal claims. The only basis for federal suit against the Glenayre is a suit for damage for violation of a federal constitutional right. Okay, like it's the Bivens doctrine. Okay, which the Supreme Court had held to be inapplicable to corporate the defendants, even when they are acting under the color of federal law. Okay, the next is authorities is the federal agents wanted Glenayre to give them the laptops right away, but it refused until the search warrant was issued. Okay, because the computer contains the confidential corporate information, and it was happy to take the computer right away from Muick for obvious reason. Okay. Anyway, the agency relationship is created by the violations of agreement and obligates the agent to act on behalf of the principal. So there was no agreement expressed or implied between the government and Glenayre to appoint the leader and agent of the former, or the Glenayre behave as it was such an agreement. Okay. Next slides, I'd like to discuss about the why my client, defendant, Glenayre Electronics, did not violate the 4th and 5th Amendment and Illinois law. Okay. Basically, is Muick had no right of privacy in the computer that Glenayre had lent him for use in the workplace. Not that there cannot be right of privacy, okay, like enforceable under the 4th Amendment if the employee is a public entity, which Glenayre we have just held was not. Okay, an employee-owned equipment furnished to an employee for use in his place of employment. If the employer equipped the employee office with a safe or a file cabinet or other receptacle in which to keep his private papers, then he can assume that the content of the safe are private. Okay, you can see the O'Connor versus Ortega, 480 U.S. 709. Okay, and also the one thing is Glenayre had announced that it could inspect the laptop that it furnished for the use of its employee, and this destroy any reasonable expectation of privacy that Muick might have had, and so squashed his claim. You can look at this United States versus Simons 206F 3D 392. I'd like to also continue another point of this, that my client did not violate the 4th and 5th Amendment and Illinois law. The laptop were Glenayre property, and it could attach whatever condition to their use it wanted to. Okay, they didn't have to be reasonable conditions. Okay, but the abuse of access to workplace computer is so common, okay, because workers being prone to use them as a media of gossip, titillations, and other entertainment and distraction. Okay, here I want to make a point that my client, defendant, Glenayre Electronic, did not invade the branch of the right of privacy. That's called the right of seclusions, and among other things that protect an individual from intrusive surveillance. So the claim is unrelated to the content of the laptop. The complaint alleged only hire a private agency to perform surveillance on the plaintiff. Okay. This is conclusional and rather that vague, but it is charged with having hired detective agency to invest the plaintiff in a manner of infringe his right against the intrusive surveillance. So my client, the claim may of course have no merit. Okay. Last, the conclusions. The 7th court affirmed the district court dismissal of the plaintiff federal claim. Of course, the court held that the defendant as a private corporate employer could not be held liable for damage for violating plaintiff federal rights. Okay. The defendants were not acting under color of state law. So more importantly, the 7th court held that plaintiff have no reasonable expectation of privacy in the laptop, a prerequisite to a 4th Amendment claim. Okay, Glenayre had announced that it could inspect the laptop that it furnished for the use of his employee, because that laptop was the Glenayre property and it could attach whatever condition to their use it wanted to. Thank you.